Alrighty, well, good afternoon and welcome everybody. Thank you for joining us today. My name is Andrew Doffney and I'm the Instruction and Outreach Librarian at the New Jersey State Library. And it's my pleasure to present our speaker for today, Nina Peckman, who works for the Advocates for Children of New Jersey's Kid Law Resource Center as a staff attorney, specializing in all aspects of education law and as a member of the Special Education Practitioners Work Group and the Education Law Committee of the New Jersey Bar Association. She takes part in education policy agendas. She is fluent in Spanish and English. She primarily assists parents by explaining the law and helping them advocate for their children in school, including by reviewing and explaining school record and writing letters to school staff. Nina negotiates with school board attorneys, attends school meetings, and state mediation with parents. She earned her JD from the Benjamin N. Cardozo School of Law in 1985 and her BA from Rutgers College. So welcome, Nina. We're really excited to have you speak for us today. Today we're going to be talking about things that you can do if you have school-age children in terms of what's legally available for you and some resources to help ensure that your children are receiving the the education that they deserve based on what's in the law and what are the practices in New Jersey. So but before we jump into Nina's presentation, just have a few housekeeping items to go over. We will be taking your questions at the end of the program, so you can submit them to us using the Q&A or the chat feature in the Zoom dashboard. Today, we do have a hard stop at 1 o'clock, so if we don't get to all of your questions, you can reach out to Nina directly or the Advocates for Children of New Jersey. We'll be providing that contact information for you. Nina has graciously provided me with a copy of the slides that I will be uploading to the chat, so you should be able to download them from there. If you can't download them from there, don't worry, they will be available as an attachment in the follow-up email that I will be sending everyone. There will be a survey available at the end of the webinar, so if you have time, we ask you please complete the survey. We really, truly, we appreciate any and all feedback that you can give us. And if you want more information on educational rights, including children with special needs, you can visit the ACNJ's education page available at the web address on the screen there. And I will put that in the chat once we get under the way too, so that you have a live link to it. One last thing that I have for you is just a brief overview of the Zoom dashboard. This is what your dashboard should look like if you're using a PC or a Mac. If you're using a mobile device, the dashboard may look a little bit different, but all of the features will still be there. In the bottom left-hand corner, you can check your audio settings. So if you're using an external listening device like a headset or earbuds, you can check to make sure it's connected properly there. At any point during the presentation, if you have any issues, there's a raise hand button here in the middle. You can click on that and that'll alert me. I will send you a message in Zoom and hopefully be able to resolve any problems that you are having. And then, as I mentioned, if you do have questions, you can use the Q&A or the chat buttons to get in touch with us. And again, we have a hard stop at 1 o'clock, so we will take as many questions as we can. So, Nina, that is everything that I have, so I can turn it over to you now.
Well, thank you, Andrew, and thank you, everyone who's participating today. I'm very happy to be here. A little about ACNJ. We are a nonprofit organization. We address health, welfare, education, juvenile justice, and other issues affecting New Jersey children. Andrew describes our program. I just wanted to add that the mission of my program is to help parents and school districts resolve disputes informally without litigation. So while we offer consultations, assistance at school meetings, mediations, and settlement conferences, we don't litigate. Okay. I'm sorry about that. Okay, this presentation is intended for informational purposes only. So that means it does not constitute legal advice. And as Andrew suggested, you can feel free to contact ACNJ for answers to specific issues. And you can contact me as well.
We're not seeing the slides.
I'm not seeing the slides. Oops, I'm sorry. You're not seeing the slides.
You just have to reshare them.
Do you see the
It looks
slides?
good.
Oh, sorry about that. Okay. Okay, so special education law is based on federal and state law. And in addition to that, case law establishes rules regarding how education laws are applied. And then is also federal and state guidance through which those schools aren't absolutely mandated to follow, are very suggestive of school responsibilities and parent rights. So special education is available to children from their third birthday through the age of 21 if they need those services after they're 18. Uh, a child must have a disability that affects learning in school and that requires special education services. Now, parents have the right to participate in education decisions, and for some decisions or actions, their consent is mandated prior to the school implementing a decision or an action. The federal and state law define who is a parent for education decision making as a birth or adoptive parent, unless a court order states otherwise. A person acting like a parent, such as a legal guardian or relative, usually this can be accomplished by the parent writing a letter to the school district, but sometimes you may have to do something formal through the county uh, offices. A resource parent can make education decisions. If these parents are not available, birth or adoptive or another legal guardian or a resource parent, then either the school district or a family court judge has to appoint someone known as a surrogate parent who's a parent just for education decision making purposes. And there are requirements and conditions in order to be a surrogate parent. The adult student can also make education decisions. And another thing just to note is that state agency representatives are not parents. So this frequently can come up, or most commonly in my experience, is a child who is involved with the child welfare system. So state employees, including from the Department of Children and Families, that's caseworkers, anyone involved with the court system. These are people who may not sign consents to special education related procedures, things where a parent has to provide consent. If a parent person is not available, again, then a surrogate parent has to be appointed. And I'm just going to say, in presenting this overview of the law, it is focused a lot on parents' rights and concerns. And I try to include topics that are based on common questions and issues that I hear from parents. There are times when, as I said, school districts must obtain written consent from the parents, such as when for the initial child study team evaluation and for reevaluations, for an initial eligibility determination and an initial IEP, to release records to unauthorized individuals or entities. This usually would refer to individuals or entities who aren't employed by the school district. Each time the school district wants to access private insurance, and the first time a district wants to access public insurance or benefits to help pay for services. To excuse an IEP team member from a meeting, for the parent to waive reevaluation rights, or to amend an IEP without a meeting. I want to just note that subsequent IEPs, the IEPs after the initial IEPs, do not require a parent's written consent. So for the subsequent IEPs, they will automatically become operational after 15 calendar days from when the parent received a final draft, unless the parent and IEP team, the school staff agree to extend this period of time. I suggest in those cases it's good to get that in writing so everyone is in agreement regarding the ongoing negotiations or discussions about what a final draft should look like, or unless a parent files for due process remediation, which I'll talk about briefly. Um, uh, Also, I want to mention that parents have the right to withdraw their consent at any time. So after they've given the consent, they can withdraw it. Parents also have rights regarding meetings. Meetings have to be scheduled at mutually convenient dates and times. Parents have to be given the option to participate in meetings via phone, virtually, or in person. So these days, most meetings seem to be scheduled virtually, but if a parent for any reason can't utilize this option, then an in-person meeting will be necessary. Parents have to write to the child study team in advance if they want to record the meeting, because then the child study team can also record the meeting if they need a translator, or if they plan on bringing a lawyer, an advocate, or other professional. I always suggest to parents that they take the time to go over the current IEP and evaluation documents, and even share them with treating professionals to get that professional's insight regarding questions or concerns to raise at a meeting. And it just helps a parent prepare them for that discussion and to raise issues at that time. Now, school districts also have responsibilities to provide notice to parents. They have to provide written notice 15 calendar days before a proposed decision or action concerning the identification, evaluation, classification, program placement, or proposed IEP changes. Now, as to notice, when districts provide the parents with the evaluation planning document, the final IEP, the IEP amendment document, the eligibility statement, each of these documents serve as notice of the district's proposed action to which a parent has to respond. I understand some districts may send out separate notices regarding these events, but some districts will just provide these documents. So these are a lot of technical terms, but it's important for parents to understand what these terms are, what they mean. In terms of what a notice must include, a description of the proposed decision, reasons why options were considered and then rejected. So they may have discussed should the child be what the classification of the student should be. And maybe they rejected certain of the classifications, and I'll be discussing the classifications a little later. The school district should explain why certain options were rejected. The notice should include the parents' appeal rights, organizations that provide information and assistance, and annually a parent should receive a copy of the prize, which is the publication published by the Department of Education, and that explains the special education process and rights. Regarding translation, parents have the right to translated written notices. Now, this is not just for special education, but for other subjects where formal notices are required, such as for discipline issues, as well as to translated district information that all other parents receive. So, for example, for back to school nights or other events, they should also receive translation services at meetings. And while New Jersey doesn't currently specifically require translated IEPs and other special education records be translated, our education code strongly suggests that this is the only way to provide parents with all the elements of what a formal notice must include, at least in the spirit of the law, to ensure parent participation, and that when they provide consent, that it's informed consent. School districts also have responsibilities to respond to written requests from parents. They have to respond within 20 calendar days, and if it's a request that requires a meeting, then the meeting should be scheduled within 20 calendar days. Parents should send these written requests to their case manager. They can copy a director of special education if they would like, and these written requests are required for an initial evaluation, for an eligibility or classification issue, for a reevaluation, for a placement and IEP implementation issue, regarding concerns or requests to change the IEP. And while parents should clearly use written requests to ensure their children's rights are implemented, and now this is now me talking, and I believe that it's supported again by the spirit of the law. If parents make repeated verbal requests or parent concerns, in writing that district staff ignore, arguably a district could be responsible, even if the parent didn't use this formal written request for the negative consequences of failing to respond to the parent concerns, such as if the district ends up overlooking a student's potential disability. So this slide talks about the time frame. So from when the parent makes a written request for an evaluation, the child study team has up to 20 calendar days to schedule the evaluation planning meeting, which is also the identification meeting is known as. And then if at that meeting it's agreed that child study team evaluations will be conducted, then the school district has up to 90 days from that written consent to conduct the evaluations, have an eligibility meeting, have the IEP development meeting, and to implement the IEP. And I want to stress, districts have, these are like maximum days. A school district could accomplish this in less than the maximum days. If an IEP is implemented, then around the anniversary of the initial IEP development meeting, there should be an annual IEP. And after the dates of the initial child study team evaluations, a child who remains eligible is entitled to be evaluated every 3 years. This is also known as a triennial evaluation. And I just want to comment that while it's a good idea to start the process early enough in the school year so that an eligibility and IEP meeting can take place during the school year when the student's teachers are there and can be part of the meeting, and with the opportunity for the parent to see potential school settings, child study teams have to work in the summertime, and even if the school staff don't work, then the districts should use outside agency child study team professionals for the meetings. So these meetings can take place all year, and there should never be a situation where a parent or a school district should delay this process if it's believed that the child needs an IEP. Now, the child study team evaluation process starts with what's known as referral, which is simply requesting child study team evaluations. This request can come from anyone, a teacher, other staff person, a child's doctor, and of course the parent. At the same time, the district has what's known as an independent duty to identify children who may have a disability through the evaluation process. And this is regardless of whether or not they receive a request for evaluations. And school districts cannot condition child study team evaluations upon the parent providing a report from a health professional. If they think the child, the child's school performance or conduct suggests the child may have a disabling condition, the schools should start the evaluation process without delay. After the parent signs after the parent sends a request for child study team evaluations, between that time and when the identification meeting is going to occur, that evaluation planning meeting, that 20-day calendar period, a couple things should happen. The child study team should confer with the school nurse to obtain current health information. Sometimes this child may have a health condition, and that's the reason why the child has learning difficulties. It's not a special education issue. On the other hand, sometimes the student may have a health condition that is one of the reasons why the child should be found eligible for special education and support the need for child study team evaluations. Someone from the child study team should also consult with the teacher regarding how the child is functioning in the classroom and should observe the child in the classroom. This meeting, the evaluation planning meeting, is attended by the parent, who can invite other individuals to support them in this meeting in terms of what evaluations should be conducted and eligibility for evaluations. And the child study team, who is the school psychologist, a school learning disability teacher consultant, um, a school social worker, and any other necessary staff whose expertise is required based on how the student is functioning at school. So that could be a speech specialist, occupational or physical therapist, or a behaviorist. A teacher who is familiar with the student should also be in attendance. If there is no such teacher, for example, if the student is new to the school, then a teacher who knows about the district's program should be present. And here are a list of, it's not an exhaustive list, but persons a parent might invite to a special education meeting and have the right to invite a specialist to evaluate the student, a treating health professional, other community providers, such as if families are working with social service agencies, if they're working with professionals from the Department of Children and Families, for example, perform care, outside therapists, the student, if appropriate, an attorney or an advocate, and other individuals to support a parent. I sometimes suggest a parent to bring another adult, someone to take notes at the meeting so that the parent can pay attention to what's occurring, and that can be helpful to the parent. At this evaluation planning meeting, if the school is going to conduct evaluations, they have to conduct at least 2 evaluations, but usually the district will do an education one that assesses what the student has learned, a psychological assessment that assesses the student's learning potential and can also assess social emotional factors, and a social work assessment, which is an interview of the parent regarding relevant health and family history. A functional assessment of academic performance should also be conducted, and that really comes through the teacher's observations and data, classroom data. And also if behavior seems to be one of the significant reasons why a child may be eligible for special education, then a functional behavioral assessment should be conducted. Here is a list of other possible evaluations. I'm not going to go through them, but they're here for your review, and you have this in the PowerPoint. But I do want to talk about the functional behavioral assessment for a moment. So this is an assessment that's going to be conducted by a trained certified behavior analyst who observes the student in school, collects data from the observations and analyzes the data in order to develop a behavior modification plan. The assessment should be conducted over several days, so the evaluator isn't seeing the student on the best or worst day. It should take place in different locations in the school at different times of day to capture a full picture of the student's behavior issues. The evaluation report and the resulting behavior plan, if the student is found to need one, should describe the specific behaviors that are being targeted to improve, identify what are the triggers of the student's behaviors, and include modifications to remove or reduce the triggers and positive supports to help the students overcome the negative behaviors. And I just want to go back. While I said, the professional who conducts this, I mentioned it should be a BCBA. I think that a master's level professional, a psychologist who's also a BCBA, are the appropriate professionals to conduct this kind of evaluation. Parents have certain rights in evaluations, requesting evaluations that the child studied him didn't suggest. Refusing to provide consent to evaluations, although in this case a district can file for due process to try to obtain a court order for the evaluations. And I just want to note here, while a school district can compel a parent to consent to evaluations through court order, districts can't compel a parent to agree to special education services. The parents can provide evaluation reports to the school district, to the child study team, which must then be considered in developing an IEP. And I usually suggest that parents, if they can, to provide these reports prior to a meeting so that the team has a time to, consider it and digest it and be able to discuss it at the meeting. I also want to just take a moment to talk about a district's duty to consider the parents' evaluation reports and the opinions of treating physicians. School districts don't have to agree with the reports. They don't have to implement all the recommendations, but they do have to consider these. And again, this is, in my, I guess, opinion in terms of, keeping the sort of the spirit of the law. I would say that in order to fairly consider the opinions of private professionals, district staff should be prepared to explain why they disagree with those opinions if they do, and to give parents the opportunity to address those disagreements by, for example, going back to the professional and getting more information. So, here are tips regarding private evaluation reports that usually I give to parents. So the parent should ensure it's from a professional qualified to give the opinion that's being sought. This professional should identify the assessments that were used and observations that explain the professional's reasoning, and the report should have a very clear statement of the diagnosis, how the disability will affect the student in school, and specific recommendations. I mean, in my experience, more comprehensive reports from private professionals are more useful than ones that are, sort of brief and general. Other tips. I suggest parents to share the current IEP and relevant school evaluations with the private evaluator, so they can review it before they form their own opinions, or at least review it before they make recommendations. Parents can also sign a release so that the evaluator and school staff communicate, so that the school can, if there are things that they want to clarify that aren't clear in the report, so they can do so, and also so that the evaluator can get the school's staff's impressions and to help them in formulating the recommendations that they make. Finally, parents should be aware that they don't need to share the results of private evaluations, or that they can instruct an evaluator to keep confidential any sensitive information. So there's certain information that, family information or student experiences or issues that really don't impact what's being addressed in school, and don't and maybe the sensitivity outweighs any benefit of sharing it with school staff, and so that information doesn't have to be shared. The eligibility meeting is the meeting where, this is what it sounds like, where the student's eligibility will be determined, if the student is eligible, and if so, what the classification should be. At least 10 days before this meeting, parents should receive copies of the child study team evaluation reports. If they don't receive them 10 days and they don't have time to review them, they can always ask to delay the meeting. At the meeting, all the participants sign an attendance sheet, which the parents should receive a copy of. The child study team, so those members that did the evaluation should explain their evaluation reports, the results, and any recommendations. And this is the time that the team should also discuss evaluation reports that the parent provided. The child study team will propose what they believe is the primary basis for special education, which is the classification. Of course, the parents are involved in this decision. There can be discussion over, what's the appropriate classification, and there may be discussion regarding whether the student should be found eligible, of course. If the child study team determines that the child is not eligible, then they need to explain why, and whether the child is eligible or not, the parent must receive a written eligibility statement that explains the child studies team's reasoning for their decision. Here is a list of the special education classifications. Sometimes parents get confused between classifications and diagnosis. These are the classifications come from the federal law. And as you can see, they may not line up with specific diagnoses. I'm not going to list them. They're here for your review. What I do want to just talk about is classification is based on the main factor that is deemed to be impeding the student's learning in school, with multiple disabilities referring to students who have multiple disabilities that equally impact the student's ability to learn, although these are usually students with severe disabilities. Regardless of classification, though, the IEP document must take note of every disabling condition of each of the student's diagnoses and provide services for all the disabling conditions that are impacting the child in school. So, for example, if a student is classified as autism but has a specific learning disability, the IEP document should explicitly state what those learning disabilities are and address them through modification supports and create goals for those disabilities as well. I also want to just mention that IEP services are also available for students who only have behavior-based disabilities. In other words, regardless of the student's learning potential, a student could be very bright, could have the potential to have grades, may even have good grades, but if they are, because of their behavior disability, they have to work 10 times as hard. They are losing time in the classroom. They are repeatedly discipline is having a negative impact on them. These are reasons why a child could be certainly should be evaluated to determine what's the basis for those behaviors, what's behind them, and could be eligible for special education services. Um, if counseling is provided, it's appropriate to include specific counseling and social emotional goals. But even if counseling isn't provided, social emotional goals should be included in the IEP, because there may be things that then the teacher is implementing in the classroom to support the student's learning. The student's behavior plan, if one is created, should be included in the IEP document. This slide contains the list of IEP team members. Again, for your information, I'm not going to go over this slide, but it's for you to consider. And then I'm going to talk about the IEP development meeting. And I'm going at a rapid pace in the interest of time, so I hope that you can you're getting a good overview, but again, you'll be able to go learn more about these topics in depth in the resources that are provided. For example, one of the resources is our updated guide to special education that covers all these topics in depth, and that's one of the links in the attachment. So the IEP development meeting, which usually takes place after the end of the eligibility meeting, but for good reasons. For example, sometimes the eligibility meeting, there's a very thorough discussion. It takes a few hours, and the parties decide better to start with renewed energy at another date to discuss the IEP development meeting, which it shouldn't be delayed, but that might be one reason. Another reason would be if the parties decide that as a result of the discussion of the evaluations that maybe they need more information in order to decide what should go into the IEP. At this meeting, again, the participants are going to sign an attendance sheet, which the parents should get a copy of. After all the IEP team participants, the school staff, the therapists who conducted evaluations, the parents, people the parents invite, after all their input is received and discussion is had, then the case manager is going to discuss the proposed IEP. Throughout this process, this meeting, parents can ask questions, they can request particular services and or type of class or school setting that they think their child needs. In terms of the IEP, the law isn't specific. An IEP, can be provided. The draft can be provided before the meeting, during the meeting, or following the meeting. If it's following the meeting, it should be really shortly after the meeting. And if a parent can ask the child study team to see a draft before the meeting, and sometimes I know child study teams may not have it ready until that day, but if it's available, the child study team should provide it, I think. Parents cannot be required to sign the IEP at the meeting and should never sign the IEP at the meeting, is my advice. They should review this IEP draft. IEPs are complicated documents. It's an agreement between the parent and the school district regarding the services that are going to be provided to the student during the course of the IEP, which is a 12-month period. And they can negotiate changes to the draft before signing the final IEP, and should take the time to review it. If they have questions, they can go back to the case manager and ask those questions. And sometimes parents aren't entirely in agreement with the proposed IEP. The IEP can be implemented even if there isn't complete agreement, or even if the team decides that they'll conduct other evaluations. That should not hold up implementation of the IEP. An example of when a parent might agree in part or disagree with some parts. The parents maybe agree with all the services, but they disagree with the placement. The parent can still sign the initial IEP, which can be very important, because without the parent's signature, the initial IEP won't go into effect. And the parent can preserve their disagreement in the parent concern section, which I'll talk about briefly a little bit later. They can, submit the signed IEP with a cover letter, just clarifying their disagreement. So the parent could have the IEP implemented and file for due process, immediately or shortly after, or sometime later, regarding those parts of the IEP that they disagree with. So this is just a kind of an overview of important IEP components. The IEP is going to state the classroom setting, the school setting, the related services. These are the therapies and other services the student gets to enhance their education program, considered essential to their ability to learn. Other services such as an aid or a shared aid, transportation, extended school year. Modification section of the IEP sets forth the modifications the student's going to receive to curriculum to support learning and behavior in the general education and or special education setting. And modifications can be specific as to depending upon the class and the setting. Transition services are services that are meant to prepare a student for life after high school. Planning starts at age 14 or younger, if necessary, with some services including students' skills, interest assessment inventory, and instructions to build skills. The plan must be implemented at age 16 and can include vocational, instruction, life skills, community experiences, and linkage to other state agencies for services. For services for individuals with disabilities. The IEP also includes a section regarding short-term measurable goals. And this is the area where the school is kind of laying out what they expect the student will learn during the course of the IEP, and also objective ways that progress will be measured. I also want to mention the parent concern section. This is the section in the IEP where a parent can provide a statement that's to be included in the IEP. It's a place where a parent can express disagreement with various proposed aspects of the IEP or concerns regarding the program. So, following the initial IEP, the student is then going to be entitled to at least one meeting annually. This is the annual IEP, at which point the IEP team will get together with the parent, the teachers will be there, the therapists who are providing school therapies to the student will be there, other relevant professionals, again, people the parent invite. And the purpose of this meeting is to go over the student's performance, progress during the year, concerns, and to review how the IEP went and to discuss the development of a new IEP, which then should be implemented after the annual review. I do want to mention there's a new law that went into effect for this school year, so it's in effect currently. And I'm just going to recite this because it is a new law. At least 2 business days prior to the annual review, parents must receive the following written notice via regular mail and email if the child study team has the parent's email address. The notice should include what's going to be discussed at the meeting, the student's current levels of academic and functional performance, the names of any required school staff, IEP members who will not attend, and include their statement of their observations and recommendations. The parent's right to reschedule the meeting if an IEP member cannot attend, and the parent's right to provide input and feedback at the IEP meeting. And here are a list of related services. I mentioned related services is a key part of the IEP. These are examples, as other types of services could also qualify to be related services. Finally, I'm going to talk about placement. Least restrictive environment is a legal term, but it's essentially it's the place that is going to best meet the student's individual needs, while also providing the student to a maximum extent possible access to non-disabled peers and school activities. And it should be based on the student's needs as demonstrated through the evaluation reports, data, teacher and parent observations, etc. It's not a particular place. It's always dependent on the student. So it could be the gen ed setting, resource, self-contained, out of district, residential, hospital, or home setting. And importantly, it could be a combination of these settings. So for some students, their least restrictive environment requires them to spend part of the day in the gen ed class and part of the day in the self-contained classroom, et cetera, et cetera. So it's a full range of placements in a variety of settings during the day as needed. In terms of students' rights for reevaluations, the triennials that I mentioned, parents may, but do not have to waive this right. I never suggest parent waive the right to this evaluation because they provide objective information about how the child is progressing and how the student is currently functioning. Reevaluations can occur sooner. It doesn't have to wait for 3 years, and new evaluations can be requested if problems arise. Reevaluations, unlike the initial evaluations, have to be completed within 60 days of the written consent. And again, a good suggestion is for parents to keep in mind when that annual review is, and so that the evaluations are ready to be discussed at the annual review, 90 days ahead of time, or 2.5 months ahead of time. A note be sent to the child study team if the parent hasn't received an invitation to an evaluation planning meeting to get that scheduled so that the evaluations can be completed in time. If a parent disagrees with evaluation results, they can request an independent evaluation. These are evaluations that are conducted by a specialist not employed by the district. They can, disagreements can be regarding how the evaluation was conducted, the validity of the report, the accuracy or the thoroughness of the report. So, for example, if the child study team left out certain assessments or left out certain evaluations, if the student doesn't speak English very well and the evaluation was conducted in English, if the professional wasn't qualified, these are just examples of why there could be a disagreement with the result. When the school district gets this written request, the school district must either agree to the parent's request or file for due process within 20 days of receipt of the parent's written request. Independent evaluations can also be requested if the child study team refused or failed to conduct an evaluation that they should have conducted as part of an initial evaluation. In response, a parent can ask for an independent evaluation, or they can renew their request also for the child study team to do the evaluation. School districts and the parent will get to choose who that evaluator will be. The district typically will provide the parent with a list of potential evaluators. There should be a list. It can't be just one or two. They should provide a list of, usually it'll be board approved evaluators, but parents can also suggest an evaluator that's not on the board approved list. And usually agreements regarding the evaluation procedures could include things like what specific assessments will be done, the qualifications of the evaluator, whether an observation should be conducted, or the setting of the evaluation, and districts have fee caps that should be based on customary rate in the geographic area, but the fees that private evaluators charge also can be negotiated. And finally, if there's a disagreement with the school district, here are sort of suggestions of the path parents should take. Again, coming from my point of view, that when at all possible, it's good to try to work these things out informally. So parents should get records of the child study team records, make sure they have the progress reports and data, formal and informal assessments to help them make their argument, their the reasoning for whatever they're requesting. They can write to the principal regarding behavior incidents and for discipline records if that's relevant. Community providers can provide written reports, information, participate at a meeting. Parents should speak to teachers to ask for their impressions. And again, they can ask for another IEP meeting to try to resolve an issue. They can appeal child study team and IEP decisions to a district's director of special education. I think they can consult. I would say they should consult with an advocate or attorney before filing for mediation or using one under the other complaint processes to make sure they understand applicable laws and strategies for resolving issues. And finally, if these efforts don't help, they can request mediation, due process. There's a complaint investigation proceeding. They can also complain to the Office of Civil Rights. There are limited circumstances where a parent has to file for mediation or due process within 15 calendar days in order to preserve their rights. And I'm going to talk about that here for a second. Stay put refers to the parent's right to prevent proposed changes from going into effect pending the resolution of a mediation or a due process proceeding. They have to request mediation or due process within 15 calendar days of receiving a written notice of a change that's going to take effect immediately. However, for IEP changes that won't go into effect until a future date, such as services maybe will be discontinued in the following school year, or for an IEP meeting that states that a student is going to graduate at the end of the year. In these kinds of cases, a parent can request mediation or file for due process just before those IEP changes go into effect and obtain state put. And I know I've talked later than I should have. But that is the end of my presentation. I have some slides here about due process, and here are resources. I really thank you for attending, and I just going to reiterate Andrew's remarks that you're very welcome to ask me questions. I know that I went a little late today.
All right, thank you so much, Nina. There are some questions that have come in. Okay, the first question is, I'm part of my district's special education parent advocacy group. Do you provide presentations for parent groups?
I do.
All right. How is consideration proven? Are there any documents?
I think I think that there are no documents, but I just think that it's a conversation. I think really parents straightforward conversation. I know I see medical reports that I don't think me explain the student's disability or the reason for special education. So if a doctor submits a letter and it just says the child's diagnosed with ADHD, I think this child needs special education services. To me, that's not sufficient to really explain, to justify, unless that the child requires special education, unless there's something more. I think it's more, there should be a discussion, there should be a dialogue, and the school district should be willing to speak to the professional. So it's more just the school's willingness to engage in a conversation and consider other information.
Is your work with parents pro bono?
It is pro bono.
Um, in what situations can a school limit its response to a child fine referral to just a screening rather than a full evaluation?
Um, if the parent makes a written request for an evaluation planning meeting, that meeting has to occur. So they can't refuse to meet with the parent and have those team members there to have that conversation, having that face-to-face meeting regarding whether the child needs special education evaluations. And if the school district refuses, the parent has a clear right to file for mediation or due process to try to compel the district to do the evaluation. So maybe screening, even that's what it's, I'm glad that's a good question because screening sounds like it's a prerequisite to be considered eligible. It's better. That's the district's responsibility to get some background information around the child. It's not a prerequisite to this be able to attend this meeting and be considered. Now, they may get information during that time that makes them think the child isn't eligible, but they have to make a determination. The parent has to get something in writing, and the parent could appeal that decision if they don't want to evaluate.
Is any action taken as a result of any disagreements within the parent concern section, or will the parent be responsible for initiating actions to review and remedy any disagreements?
Well, the parent concern section, the purpose of that is for the parent to document. It really is simply to document their concerns. It is a record, so for the parent. So let's say if for if a student is going to be in special education for long term, and then later on there's a let's say the parent expressed that I believe my child should be in a out of district placement, for example, or in a self-contained classroom, and the school has the child in a gen ed setting. And then years later, let's say, and the student, hasn't making progress and is, maybe is even regressing. And the parent, or another example would be, I think my child needs speech services and the school isn't providing it. And every year the parent says, well, I really think that you should get speech services. And so then, later on, that establishes, let's say, a record that maybe, which I didn't get to speak about compensatory education, but compensatory is a remedy when uh, school districts fail to provide services that either they should have had reason to know this child needed, and or services that were in the IEP that they didn't provide. So in that example of services that they should have reason to know the child needed, so that concerns about services or other disagreements that are in the parent concern section year after year maybe provide evidence of the school had knowledge of something. In terms of taking action, that really is something that the parent has to do through that advocacy process, speaking to the director, utilizing those strategies, trying to get, asking for a meeting for an IEP amendment, or exercising, their appeal rights through the Department of Education, through mediation and due process.
Can you speak to the 3-to-1 workload plan for IEP services?
The 3-to-1 workload plan. I can't speak to that because I'm not, um, but I'm the 3-to-1 workload plan. But if you email me, if you email that question, I'll be happy to get back to you.
It says the 3-to-1 model is a component of the workload approach to services in which 3 weeks out of each month are primarily designated for direct intervention.
Again, that's not a term that I'm familiar with, and I'm glad that you um, are raising that question, and I'm happy to look into it. And please, email me after this presentation, and I'll be very happy to either speak to you or get back to you regarding that.
Um, how does this relate to physical disabilities? My son is on track developmentally, but will need some limited support to attend school.
So, having a physical disability is, one of the a child couldn't be classified. I mean, if it's an orthopedic impairment or if it's a developmental delay, and a student would be entitled to special education if it's impacting learning. If it's just an access issue, if the student is can be in general education settings, then under the American with Disabilities Act and Section 504 of the Rehabilitation Act, they can have a plan to ensure the student has access to the school building and to extracurricular activities, modifications, et cetera. If it's impacting learning in some way, then in addition to addressing these sort of access issues, modified gym and the other issues, if it's impacting learning in some way, then they would be entitled to special education services.
All right. And last question. You've talking a lot about how this works for children in school districts. Can you speak a little bit to about the children who are maybe in a pre-K program or in daycare? How does that differ?
So, students in preschool are eligible for special education. Parents who, let's say, I'm assuming, is your question as to students who are in private preschool?
Right. Yes. So
Private,
maybe, yeah.
so in private, so parents have the right. So for preschool, the district where the parent resides is responsible for evaluating that preschooler, whether or not the preschooler attends the in-district program or a private preschool in another district. So parents can get their child evaluated through the school district where they live and get an IEP developed. And the there are funds for, it's based on a formula of the percentage of students who are in special education versus this general education students in the district. So there are funds allotted to provide limited special education services to any child who is in a private school. The difference is that after preschool is the district where the private school is located that's responsible for the evaluations. So limited special education services and related services can be provided to the child in the preschool, private preschool where the child is attending.
All right. Well, thank you so much, Nina. We really, really appreciate your time here and sharing all of this information. It's a lot to go through, and as I said before, if you can access the handout, which is the presentation slides, it will be available in a follow-up email, so you'll be able to access it there. And I put Nina's contact information in the chat, so you can get it from there, or again, you can get it from uh, the presentation slides, or visit the Advocates for Children of New Jersey's website.
And thank you all for attending and for inviting me to this presentation, Andrew. Thank you.
Not a problem. And everybody be safe, be well, and hopefully we'll see you soon.